Good morning. I'm happy to be back for another discussion on client perspective in an arbitration. And I'm very excited to interview Shell's Associate General Counsel for Disputes, Gabriel Costa, along with Pedro Maciel, a partner at Lefosse and one of the top arbitration lawyers I know. I must say, back when I met Gabriel about 15 years ago, he was a visiting associate at a US law firm in New York. And he was already extremely knowledgeable in arbitration. So it's not surprising to me that he has become one of the most active in-house counsel of the Brazilian arbitration community. So much so that in addition to overseeing Shell's disputes docket in Latin America and in the US, he currently serves as the chairman of the ICC Brazil Arbitration and Alternative Dispute Resolution Commission. Welcome, Gabriel, and thank you for accepting our invitation.
No, thank you very much, Erica. It's quite a pleasure to accept the invitation and being here today with you and Pedro. A big thanks to the Arbitration Channel for the opportunity. That would be a great thing to do anyway, but being interviewed by you and Pedro makes it particularly near to my heart. And thank you for the kind words. But if I have any merit on my own, having get where I am, it's in great part due to the fact that I took most advantage of the opportunities that I had to work with both of you. So thanks for that. You have not a small part of that.
You're too kind. Look, Pedro and I will take turns asking you some questions. So I'll get started. Pedro, please chime in as you wish. So let's get right into it. Gabriel, so you've achieved remarkable success in your career at one of the world's largest oil companies. And frankly, it's quite impressive to see a Brazilian lawyer based in Brazil that is overseeing disputes involving a British company, not only in Brazil, but across Latin America, the Caribbean, and even the United States. Could you share with us the journey that led you to your current position?
Yeah, sure. Thank you. I've been practicing law as a fully qualified Brazilian attorney for about 20 years. I think just over that. I graduated, got my first law degree, and then a postgrad in my hometown, Porto Alegre, followed by a LLM in Chicago. I think I've been working with dispute resolution since my first internship, which I got in the first year or second year of law school. And it was just by chance, that I was admitted as an intern in one of the largest Brazilian firms down there, and I was assigned to the dispute resolution practice. And I've been working, in different capacities with dispute resolution since then. Moved to São Paulo after a certain period of time. From São Paulo to Chicago to the LLM, back in Chicago, back to the US and to New York to do a foreign associate gig at one of the largest US firms. And from them, finally back to Brazil to join Shell. So I've been with the company for just over 12 years. I have always been in Shell's litigation department. I joined as a legal counsel, as a senior counsel, the managing counsel for Latin America, then associate general counsel covering Latin America, and until recently, for the past 3 years, part of our docket of disputes in the US too. What I would say is that I've never exactly planned the next step, was just trying to move along and doing the best I could in every single role I had. I think I was very fortunate in counting on excellent role models and mentors along the way, the two of you included, and working in an organization that really walks the talk and gives a platform for everyone, everywhere to succeed, and play a role. Shell manages his legal issues in litigation, and in my case, it's just about, be curious, kind to people, and try to be the best job you can. I remember when I was moving to the US to work with the US firm, when you and I worked together for a while, that was quite a good experience. And I asked Pedro, who I was working with down here at the time, any tips that I should take with me, and said, I don't know. what kind of work they will exactly ask you to do, but if they ask you to make a copy, just take the best goddamn copy they ever seen. So that was a life advice. So I guess it's been working.
Yeah, no, I do remember that at your time, when we worked together here in the US, you were here for a year, I think, but it felt maybe it was more than a year because it felt like a very long time. You were integrated with the group in a way as just, any other associate. So
thank you.
That's my memory.
So Gabriel and Erica, it's a real pleasure to be here with you, and doing this interview with Gabriel is really awesome. I I do recall that episode of the best copies, but tell us more about your tell us about your day-to-day activities. What you do. I think it'd be interesting for everyone to understand what is your role and what you do in your day-to-day activities.
Sure. Thank you. I think I probably could divide my day-to-day activities in 4 different buckets. I think the first is what is my job title? As Associate General Counsel for the region. In that capacity, I should manage, and I do manage, the team that is responsible for essentially handling the disputes and providing all kind of litigation-related advice to all shell entities across the region. And that includes, just for administrative tasks like budget control or engagement with external auditors, accounting treatment, making sure we are operating in a compliant environment. They spend a lot of time talking and reading and interacting with internal and external stakeholders, to make sure we are setting the right strategy, the right direction to the disputes. The second bucket would be my tasks as a member of Shell's Global Litigation Leadership Team. In that organization, I report to the General Counsel Global Litigation sitting in Houston. And so I'm part of that leadership team, which is entrusted to oversee the whole litigation department in Shell in the world, essentially. The third bucket is as a member of the Shell Brazil Legal Coordination Team, which I sit with my peers, leading other areas within the Shell Legal Department, focused in Brazil only. So I share some responsibilities of managing the Brazil legal population. And finally, and that's one that is I make an extra effort to do, and is something that I really enjoy, which is keep at least one matter at a time to work on as the individual performer, as we call it, as the lead in-house counsel, manage the case. It's not exactly on the job description on a day-to-day, but it's something that I really take a lot of satisfaction, and I think it helped me with a lot with the other three hats that I have to use. I try not to overdo that because time is limited, but at least one matter at a time. I try to keep it for me to manage as a leading house counsel. Now it's a well-legitimate arbitration in another jurisdiction that not Brazil.
But tell us a little bit more about what you do as a lead in-house counsel in a case like that. What exactly do you do in that case? Because I think it's probably more day-to-day in your relationships with the work, in your relationships with law firms and other lawyers and the cases themselves.
Yeah, absolutely. I think that normally starts with the initial case assessment. We follow what we used to call the litigation objective realization process. Is a very well structured guideline internally. Now we have the litigation performance framework, which is sort of the same set of guidance and rules that has been updated recently. It started with our initial case assessment, and that's normally done in-house, and engaging with the relevant stakeholders. So it might be those who have accountability for the business involved, or those who were involved in the underlying facts that can contribute with testimony and documents and corporate memory. That's the first step. Second is generally to select outside counsel. Then we normally identify those firms that we think are the best positioned to handle that specific dispute. Normally we run a request for proposal, select the firm, and then going forward is literally working as a one single team. We normally, for significant matters, we normally have some cadence engagements once a week or once every other week, to make sure that a strategy is going the right direction. That my main responsibility, actually any shell litigator main responsibility in managing the cases, other than keeping that with him on budget and so on, but it's making sure that the strategy for that particular case is aligned with the broader strategy for the group, that we are managing that piece of litigation or arbitration as our business folks in the business line would normally manage any business project, if you will. So sort of managing dispute as a business to the extent that is possible.
Oh, very interesting.
Gabriel, I hear you, before we go a little bit deeper in arbitration, which of course is going to dominate a big part of our discussion today. I hear you handle a lot of litigations as well. And now, of course, I would assume that your background in arbitration has been key for your career path, for you to be where you are at. So not asking you specific numbers, because I know you may not be prepared about that, particularly because I don't think we talked about this beforehand. But I was just wondering if roughly you have an idea of the ratio of arbitration versus litigation in terms of amounts to dispute within your department at Shell. Do you have a sense that you can share with us?
Well, I can clearly say I'm not sure about case count, but I can clearly say that the biggest or the bigger ticket, the highest exposure matters are normally subject to arbitration, except those involving the government or government-controlled entities, which sometimes by definition are not subject to arbitration. Sometimes they are, but sometimes there's associated litigation going on. But I'd say from purely commercial disputes, arbitration is by far our preferred dispute resolution mechanism. So it's where we try to go to resolve the big disputes.
That's what I thought, but I wanted to hear expressly from you.
Yeah.
So now jumping a little bit more on arbitration specifically, during our conversation, I would like you to compare the arbitrations you handle in Brazil with the arbitrations you handle in other countries. So let's discuss, or start discussing procedural aspects, for example. In terms of procedure, what differences have you observed between arbitrations in Brazil and arbitrations in other countries? Are there specific issues that jump to mind that you find quite, different or?
Yeah, I mean, I think that there's quite a few, but before going to the details, I would say that I think the Brazilian arbitration community, it's incredibly sophisticated. I think we are very, very well served with outside counsel and arbitrator and even local arbitration institutions for certain matters. And I think that should be reason of pride to all of us, the Brazilian practitioners. So that's to start with. I mean, my second general remark on that is that I have some views on those differences, and they are mostly informed by the perception of a foreign investor who has to deal and handling arbitrations, in many different jurisdictions. So the perceptions of an in-house counsel working for a Brazilian company which operates only in Brazil, for example, might be different exactly for the opposite reason. So not arguing that these views, my own views, are right and others are wrong, but just that they make more sense from my perspective. And before I go there, I forgot to say that up front, but those are my own individual views, right? They do not necessarily represent the Shell's views on the topic. I think what worries me a bit sometimes is that it seems that Brazilian arbitration has been departing increasingly from the international practice in certain aspects. And for someone who is entrusted to handle arbitrations all over the places, with stakeholders sitting in different places, that creates another layer of complexity on handling proceedings that were intended and were expected to be pretty much similar in terms of procedural aspects, but have become somewhat different. There's a couple topics that have been widely discussed recently within the arbitration community, namely use of experts. How do you use experts? Is simply the international practice of is the burden to each party to present its case the best it can, and the tribunal will decide based on what is presented to them, or if the tribunal should have the discretion or the authority to appoint the tribunal's expert, for example, which the three of us and the two of you much more than I that are very experienced in international arbitration know that it's not by any means the general practice in the international space. The tribunal have an expert. That is something that creates some anxiety to us. If you have to do it, we do. It's part of the proceeding. Again, it's not right or wrong, or that one approach is better than other from a principle or conceptual point of view. Just from handling different disputes, it causes some questions sometimes around, okay, why is that different, and does it create an additional layer of complexity in managing the case? That is one. I think Brazilian practice is somehow different in many instances in that particular regard. A lot has been said and written lately about the way the parties should present their factual witnesses, whether written statements are necessary or required, if they are optional, if they should be mandatory, and what would be the consequence of presenting or not presenting written statements. Again, from an international perspective, it generally it should, or it sounds like a given that, that's how the process normally works. You have your witnesses, you present the written statements and the procedural opportunities that will be set forth in the procedural timetable, and then you hear those witnesses at hearing, if they are called to testify. I think sometimes we spend a lot of time here discussing how to manage the witnesses' testimony, and we sometimes land in something that is different from what we see internationally, which again, I personally do not think it's in the best interest of resolving the dispute in an efficient and consistent manner, and doesn't help much in telling the history of the Brazilian, the story of the Brazilian arbitration outside Brazil.
Yeah. So, Gabriel, let me interrupt you a little bit and go back before we discuss more the witnesses and production of depositions and so on. Let's dive a little bit further on the experts. So in Brazil, we have this common trait that arbitral tribunals very often appoint their experts as if they were judges in the court procedures here in Brazil, and they have their trusted experts to the case, and they let the parties submit lists of questions and all that, and that's been that happens very, very often in pure Brazilian arbitration, so Brazilian law, Brazilian parties, and Brazilian arbitrators, and of course you probably have the opposite experience of the parties appointing their own experts and presenting the case to the arbitral tribunals in the international arbitrations that you handle for Shell. You said that this is very peculiar of Brazil, but I'd like you to digress a little bit more on the differences and advantages you see in one way or the other, and how often you see those, and how you try to negotiate or use one or another method.
Thank you, Pedro. I think from a very, very high level perspective, the reason why I like better to have the parties appoint their own expert and the tribunal not appointing a tribunal's expert, it's maybe there's something about what I mentioned before of managing disputes as a business. I mean, we would like to have as much control as we can over the proceedings, obviously in a constructive way, and leaving the parties with the ability to present the best of their case and make the case understandable, digestible to the tribunal. I think it's just part of good advocacy. And I appreciate that sometimes it's difficult, and that sometimes the issues at disputes are too complex for laypersons like lawyers generally to tackle. So there might be instances, but those should be very, very rare, in which that approach could be reconsidered. But generally speaking, it's the party's burden to put forward the best case it can. And if somehow the tribunal cannot grasp what the party is trying to say, well, that is just the burden of proof rules to be used. The case was not properly proved. That said, I can see the benefits, at least the conceptual benefits of having an expert appointed by the tribunal. Obviously, that would help the tribunal to kind of translate the tribunal otherwise rather complex issues. But in balance, it doesn't seem to be the best approach for most cases. Maybe because in my experience, I'm fortunate enough to work with good lawyers like the two of you who are able to translate complex context in very understandable and reasonable arguments to laypersons. So in balance, I would prefer not having an expert appointed by the tribunal. But again, being pragmatic, that's a matter of strategy for the case. There might be aspects of any given case that would make more interesting to have the tribunal appoint an expert. In terms of how this is negotiated, I think I appreciate that in the Brazilian practice, it's more of an issue because sometimes not even the tribunal might be willing to not having its own appointed expert. And I think that it starts with the selection of the arbitrator you appoint, right? If that will be an issue, if you anticipate that might be a key element of a strategy, that's a consideration to be given up front in considering names. Of course, not only for that reason, but for all the other reasons, that does not guarantee that you have the person you want, or that even if you are successfully appointed the arbitrator you want, that doesn't mean that arbitrator's views on whether or not to have an expert would prevail in the tribunal. But that's the first step. And the second, honestly, if it's a Brazilian arbitration under Brazilian law sitting in Brazil, we just have to be prepared to deal with or appointed by the tribunal and try to make the best out of it. Because, yes, normally it's not an easy negotiations to have, particularly if the opposing party is insisting in the tribunal appointing its own expert.
Good.
Let's dive into a little bit into the topic of fact witnesses, Gabriel. You mentioned that as well, and you did mention in international arbitration we typically have written witness statements in lieu of direct examination, a more meticulous cross-examination in hearing. I've never had a deposition in a case as counsel, but I've had the parties agreeing to a deposition in a few cases I acted as an arbitrator. And usually that happens because the parties were skeptical of written witness statements, and they preferred to have a statement based on a deposition to use that statement at the hearing. I don't know if you've had that experience, or I guess my question is broader even. In general, tell us about your experience with fact witnesses. What do you consider to be the most effective approach for hearing and examining a witness?
Thanks, Erica. Again, I think, generally speaking, the international practice seems to work well, if for anything else, because that is the practice that we are more familiar with in different jurisdictions. And I appreciate the concerns around the written statement. Sometimes there's some level of mistrust of who and how that was prepared or drafted. I must say that in many instances, I might share those same concerns. I just think that putting all in balance when you're sitting on the client, on the party's shoes, and you're trying to have a proceeding that is as effective as possible, I think the advantage of having the written statements beforehand, and then the opposing party will have the opportunity to cross at the hearing, I think makes the proceeding more, in terms of procedural steps, more predictable, and it is and being more predictable, it makes it easier for the parties to prepare. And if that is agreed beforehand, both parties will have the same opportunity, obviously, to prepare their written statements. I don't see, and I appreciate the doubts or the mistrust around that. And I think that is particularly the case when we are talking about witnesses that under Brazilian law, the Brazilian procedural law, wouldn't even be considered witnesses, technically speaking, because of their relationship with the party itself, for example, officers and directors. That can be more of a problem when the discussion tends to center around the statement be in writing or not. In most of the cases, there's a concern about the relationship between the witnesses and the party offering the witnesses.
What about the roles of arbitrator and counsel? How do you, in conducting the arbitration, Gabriel, how do you think, and how do you see their roles, and of course, again, continue the comparison between the Brazilian experience and the international experience? How do you see their behavior in the two scenarios, in the two worlds? Very different. Which approach do you prefer?
Thank you, Pedro. That's a good question. I think the roles that arbitrators play in a more domestic Brazilian arbitration, it's somehow different, and if for anything else, just because the reasons we are just discussing, right? How they will approach the expert evidence to be produced, or the testimony evidence to be produced. There will be an expert of the tribunal or not, or the parties will be allowed to present written statements or not. I think I'm not sure if there's a tendency of that's a general rule, because I must admit that lately my experience has been much more focused on the international space rather than in the domestic space. But taking that as a baseline, when we talk about all these different approaches in the international space, in the domestic space, and particularly around evidence production, there's a conceptual difference in the way counsel and parties expect the tribunal to act, and thus the way the tribunal normally acts, which is who essentially is the final recipient of the evidence. Why are the parties producing the evidence in the proceedings? We're producing the evidence in the more international space. We're producing the evidence to establish our case, to prove our case, to give the arbitrators the best case we can, with most elements that we can, for them to make a decision based on what the parties presented. So the arbitrators will almost like have a more passive role than what is expected in a domestic case, when the arbitrators would be more active in terms of determining whether or not they want an expert, or would have more discretion to determine that some evidence should be produced if none of the parties has, for example, raised the need or the desire to produce such evidence. What I see is that in international space, the tribunals tend to be more passive and more just open to receive and analyze whatever evidence and arguments the parties will put forward, rather than international, in the domestic space, arbitrating somehow sometimes can be more active in conducting the proceedings, particularly in the evidence production phase. Which again, there's probably pros and cons in both models.
And so you just said document production, so I'll pick up on that as opposed to going to my next question. Actually, something that I observed in Brazil is that the Brazilian parties tend to adopt positions regarding aspects of the procedure that are based on the assumption that the Brazilian Code of Civil Procedure would apply to the arbitration simply because the arbitration is seated in Brazil. Now, I know I have a very recent decision of the Superior Court of Justice holding that the Code of Civil Procedure does not automatically apply to arbitration, even subsidiarily, so perhaps you'll see less of this. But I've seen parties claiming that the rules of evidence of the Code of Civil Procedure would prohibit, for example, document production in the middle of the postulatory phase as opposed to after the postulatory phase, which is something very commonly admitted in international arbitration. Have you seen these issues being raised specifically with regards to the Code of Civil Procedure, or do you think it's more a cultural issue, and regardless of what the code says or not, we're gonna continue seeing this debate despite of what the STJ just decided? What is your view and experience on these issues?
Yeah, thanks, Eric. I think clearly that there's a cultural element to that. There's a cultural aspect to that, which is fine. The same way there's an American aspect, or a French aspect, or a Mexican aspect to the arbitrations conducted in the U.S. or in France or in Mexico. So that is fine, and you need to be prepared for that. Retaining international counsel or counsel with international experience and appointing the right names is probably the first step to try to level the play field in that regard. In terms of a more outright argument that the Civil Procedure Code should be applied, I haven't seen that much, except when parties are talking about the witnesses who can and who cannot serve as witnesses, that the criteria, that the impartiality and independence of witnesses in the context of the arbitration itself when it's progressing. What we've been seeing, unfortunately, it's a proliferation of motions to set aside awards with increasingly creative arguments, and most of them based on provisions of the Civil Procedure Code. And if you and I are talking about the same recent precedent for the Superior Court of Justice, that was exactly the case, though an action to vacate or award file essentially under the argument that some provisions of the Civil Procedural Code wouldn't have been applied as they should have been applied, and therefore the award should be vacated. And unfortunately, the Superior Court of Justice said that it was not the case. So I see the parties raising the arguments related to the Civil Procedure Code more in the context of actions to set aside the award. We've been fortunate in not having much of this in our own experience, but in following up and what's going on in the market, we've seen that there's a number of reports and surveys out there pointing to that direction.
Yeah. Okay. So now turning a little bit to certain criticisms that arbitration has faced, and I'd like to start with costs. The costs associated with arbitration, usually raise concerns to clients, but when you consider that a complex dispute usually takes 2 to 3 years to be resolved in arbitration, but in litigation it can extend to 5 to 10 years or more, I think it begs the question: is arbitration truly more expensive, especially for complex disputes? What is your opinion on this?
Yeah, I mean that is a thanks. I think that is a tricky one. I think generally my answer is probably no. I don't think arbitration at the end, it's more expensive than litigation as an alternative. If you're talking about the same dispute being decided by arbitration or by litigation, I think what's undeniable is that if you are pursuing arbitration rather than litigation to solve a dispute, you have a more concentrated cash flow up front. The cost, the disbursements you pay for outside counsel, arbitrators, institutions, experts, and so on, they're more concentrated not only up front, but in a shorter period of time. And that has an impact in cash flow. And that is one aspect of costs. But if you, and that is obviously, it's a very legitimate concern, if you have some priorities of preserving cash flow in first place. So that yes, that is a consideration. But that is only part of the cost story, in my view. I think the cost includes a number of other things, like the opportunity cost over time, the predictability of how much you spend, and the accounting impact that any given dispute, for example, might have in the party's balance sheet, by being resolved in 2 years in opposition of being resolved in 12 or 10 years. So those are calculations that are not necessarily easy to make, but you can make. They are doable. And if you consider all of these in the cost equation, I don't think it necessarily means that arbitration is more costly. It's certainly not inexpensive. It's certainly not cheap, because any single dollar a company like Shell puts in to resolve a dispute, it's a dollar that is not being invested in the core business. So the best arbitration is the one that does not exist. But considering that we need a method to resolve disputes, arbitrator has been serving us well, even though we could spend probably quite a few hours discussing how costs sometimes have been excessive, even in the context of arbitration.
Okay, before I give the word to Pedro, because I know I'm monopolizing with too many questions, but just because on the topic of criticisms, the first one that came to mind was costs, and another one that I think that the arbitral community has faced quite some is the perceived lack of impartiality among arbitrators, and that's, I think, a concern both in Brazil and abroad. So in international arbitration, we've been taking the guidance from the IBA for a long time. And in Brazil, I know the CBAR recently published new guidelines, and I know you're familiar with both guidelines. What factors do you consider most important in ensuring a fair and impartial arbitration when selecting an arbitrator and addressing conflicts of interest?
Thank you. No, that's a good question, because I think it goes to it links back to a dilemma, probably. If you are considering names that are very experienced in a certain industry or in a certain issue within that industry, it's very likely that individual will have worked in similar cases in the past, and in similar cases probably involving similar parties or same parties. And I think that the rules, the IBA and now the CBAR, they exist for a reason, and I think they are designed to make the proceedings or the assessment of impartiality and independence more predictable, and I think we should stick to those rules to the best we can. But the assessment the balance is whether you trust that name who has a wide experience in that industry or in that issue, which necessarily means that that person will have had experience before with the issues at hand, to decide your dispute in a manner that is impartial. And of course, independence is a slightly different, because obviously you want someone independent, but someone that, despite the fact of having previous experience, which is what you want, will be able to decide that particular matter independently. It's a very personal assignment, right? And probably is the most important decision I have to make in arbitration. That's why we spend a lot of time up front discussing the names to be there. But to try to answer your question more simply, I think the IBA, now we have the CBAR here, but mostly the IBA, which is widely used. More recently, have the Prague rules, but I'll stick to the IBA. They are guidelines, and then can or cannot be applied, but to the extent the parties in the tribunal agree that they should apply, they should apply. They're far from perfect. No rule, no guidance would be perfect, but they help. They help.
Thank you, Pedro.
Shall we move to interim measures, emergency arbitrator, and the use of courts in assistance to arbitration? And do you want to tell us a little bit about your experience with that, Gabriel?
Yeah, sure. Thanks, Pedro. Sure. I think that is obviously, again, it's a matter of strategy for the case at hand. I think a few factors to be considered. It's who is best positioned to give me the interim measure I want. Is the emergency arbitrator or the local courts, and that might involve considerations over the time frame. Do I need that interim measure immediately? And if I do, who will issue that interim measure more swiftly? Complexity of the interim measure. This is something that I really need someone that is well versed in the dispute, or is more like there's some simple run-of-the-mill kind of issue that I believe a judge not experienced in that specific industry or contract would be able to do it. Opportunity for the opposing party to be heard. Is that relevant? I might want the opposing party to be heard somehow, or I might not want, and there's obviously there's difference between my ability to get an ex parte interim measure before local courts and their emergency arbitrator. I think that the emergency arbitrator proceedings generally, take the ICC one, which we have some experience. They tend to work very well if that's what you need. If that process fits the emergency of your case at that moment. But whether or not to use them is a matter of strategy for that moment of the case. Considering those factors, I guess, time frame, complexity, and opportunity for the opposing party to be heard, I would probably name those three.
I think you're mute, Pedro. We cannot hear you.
Sorry. What about the enforceability of the emergency arbitrator decisions? Have you come across any of those issues? I had one of those in my recent experience, so that is interesting to know.
Yeah, no, that's certainly a factor. That probably would be the fourth factor. Whether or not that decision, the interim measure I'm seeking, would be immediately enforceable, or regardless of that, if I anticipate that the opposing party will resist complying with the interim measure, that might be a factor too. I have not personally faced that situation lately, in which we needed to seek an interim measure, and there was concerns about enforceability, or that the opposing party resist complying, and then we had to enforce. But that would certainly be a factor. Actually, probably one of the most important ones. No point in getting one if you cannot get the practical effects of it.
Sure.
And I think that brings to my mind the question of enforceability of awards, more generally, and the participation of the judiciary in arbitration proceedings in Brazil compared to other countries. So there is, considering concerns surrounding the annulment of Brazilian awards, now the CR published a report that a small number of awards have still, we seem to see an increased number of awards subject to annulment proceedings in Brazil. I'm not sure if this is a consequence of the increased number of awards in Brazil, or the publicity of some high-profile cases in which there might be abuse by the losing party, or if there is really something that we should be concerned here with respect to the Brazilian arbitration culture and in the recurring number or increasing number of awards subject to annulment. So I think the question is, how do you perceive the risk of winning an arbitration in Brazil, but encountering difficulties in enforcing the award compared to other countries? Same risks, different risks. How do you assess that?
Thanks, Erica. I think that is certainly an issue. I think the numbers you have seen in the recent surveys by the CBAR is one of them, that the vast majority of the actions to vacate, to annul the awards go nowhere, and they are simply rejected. That is obviously a good sign. That we have, generally speaking, that healthy arbitration proceedings going around. But the increasing in numbers of annulment actions, even if most likely they will go nowhere, that is very, very concerning. because that defeats the whole purpose of having your dispute decided swiftly and under a budget. And even if there's 99% chance or 95% chance that my award will survive an annulment action, if I have to spend 5, 6, 7, 8 years fighting for that and spending money for that and dedicating internal time and resources, that's defeat the whole purpose of having the arbitration as a dispute resolution mechanism in the first place. And of course, if you have a good award, you fight to defend that. But that increase in this kind of action is troublesome. And even though the judiciary has taken the right approach, I guess, which is a very only intervening when there's actually reasons for that. And yeah, we'll see some outliers, some decisions that annulling awards that makes no sense, but that happens anywhere, everywhere. But even if the judiciary has been very supportive to arbitration, the fact that you might have to litigate that, it's very, very concerning. Wow. And I think you see parties doing that and bringing in annulment actions without no merit, just impose an additional burden on the opposing part, maybe in views to get leverage for a settlement, whatever the reason might be. But it is a problem, and I think that does not help the credibility of Brazil as a reliable and friendly seat for arbitration when you see that happening all the time.
Yeah, it's dangerous, because then those 2-3 years that we're talking about, when you're assessing, the costs of arbitration versus litigation, are not 2-3 years anymore. Even if you're going to win at the end, it's much. It is complicated. So we got to be very careful so that doesn't become just something ingrained in the arbitration, Brazilian arbitration culture, right?
Yep.
It's a matter of time, right? It comes and goes, and it's a part of the process of maturity of the procedure. We either have arbitration or litigation. It's not arbitration with litigation afterwards, and this is going to be consolidated with time for sure.
Absolutely.
I think something else that I find delicate, and then switching here to a different topic, is this delicate balance between transparency and confidentiality in arbitration, right? Where transparency ensures the legitimacy of the institution, and I think you, as the chairman of the ICC Brazil Arbitration Commission, have been probably thinking a lot about that. But confidentiality is a key factor attracting parties to the arbitration. And then you, in your position at Shell, have also been thinking a lot about that. So what approach do you believe that can effectively address this challenge and maintain a trusted but effective arbitration process?
Yeah, thanks. Yeah, another good question. Yeah, I think, we are all, confidentiality is indeed, I think, for most companies, for most parties, one of the key features of arbitration, or at least the possibility of having your dispute resolved in a confidential matter. Not by chance, most contracts do have confidentiality provisions that will extend to the arbitration provision in those very same contracts. And I think that is a key feature, because you're just trying to resolve an issue that you are not able to resolve commercially. And if you were able to resolve that commercially, you would have resolved that in a confidential matter. So that's one. Second, confidentiality, as we know, is not an absolute right. There's a number of instances that we see confidentiality being mitigated. One example, as the first that comes to mind, is that when you are in arbitration against the government, for example, at least in Brazil and in most jurisdictions in Latin America, those proceedings, they are by definition public. You might apply to have certain information, sealed or labeled as confidential, but generally speaking, those disputes are not confidential. So that's something I would say most companies experience in arbitration. They will be used to in working with different levels of confidentiality. In purely private commercial disputes, it would be hard someone making the case for more transparency for the sake of the system. Because I think honestly that is a non-dilemma. I think we all agree, and I agree, and I think most of my fellow in-house counsel would agree that having a body of precedents of case law, depending on what's the governing law applicable to the arbitration, would be helpful to the system and to ensure more predictability. Yes, that's right. But I don't think that's a consideration you make in your very own case when it's moving on. No, you're not. No. It's hard to consider, okay, let's make this more transparent, because in doing so, we will be increasing transparency of the systems and we will be benefiting the entire system, which is true, if that would impose any risk, as slight as it may be, to get confidential information and information that you simply don't want to be made public. So, that said, I think there's an issue of the transparency within the arbitration process itself, and I think that goes to evidence production, that goes to the parties disclosing whether or not, for example, they are using third-party funding. Most arbitration rules, or many arbitration rules, ICC included, have been recently amended to include provisions in that regard that the party must disclose. So that goes to the heart of transparency too, but from a different lens. Not in opposition to confidentiality, considering the broader arbitration community, but rather the legitimacy of the arbitration process itself, leveling the play field and everyone having the same level of information about what are the drivers of each party to the extent possible.
Now, if, thinking about these, I totally understand the importance of confidentiality for the client, but if ultimately, the transparency, and talking about this transparency that would really serve the overall community in the long term by creation of, not binding precedents, we're not going to have that in arbitration. We don't even want that in arbitration, but some guidance on some issues, perhaps. Do you think that promoting, for example, the use of redacted versions of arbitral awards, or postponing the use of the awards and protecting the parties' case for a certain time, but making it public after a certain time? I think arbitral institutions have been addressing this challenge, implementing rules in this sense. Do you think that those are helpful? Do you think that, it's perhaps a way of striking a balance between transparency and protecting the parties' confidentiality?
I think those provisions are helpful, indeed. I think they are helpful. I think, once the dispute is resolved, the parties having the opportunity to decide whether or not they would agree with a higher level of disclosure, if you will, or transparency by ICC, for example. I think that is helpful. I think that the fact that ICC asked the parties about that is very helpful, because it makes the parties to reflect on whether or not that would be a good thing. We take that opportunity very seriously, and we analyze very carefully if there's any particular reasons why we would not want to do that, rather simply go by default and say, no, we're not doing that because that's confidential, period. But to your question, Eric, I think the answer is yes. I think those provisions are helpful, and they help to increase the level of transparency while still keeping the level of confidentiality under the parties' control.
Agreed. Pedro, do you have anything on this or something else?
No, I was thinking we should move for what keeps Gabriel busy these days, shall we? And in the future? What types of matters, Gabriel, are keeping you busy these days? And then we'll talk about the next years.
Yeah, well, thanks, Pedro. I think I would say there's maybe 2 or 3, maybe 4 sorts of categories of issues or matters. I think one is, it's the usual regulatory issues, regulatory concerns. Energy is obviously a highly regulated industry everywhere. So there's to the extent that you are investing and you are entering contracts that normally tend to last for decades when you're talking about the traditional upstream of oil and gas part of the industry. And regulations in Latin America tend not be as stable as we would like. So there's always some regulatory issues along the way, and that requires attention, and eventually some of them requires litigating, arbitrating them. On the renewables space, in the more known oil and gas part of the industry, I think there has been a lot of activities, both locally in Brazil and across Latin America and globally, and consolidations and acquisitions and new deals. And that normally generates disputes. So even if you are investing or if you are divesting, the more intense the business activity, the investment activity is, the more intense tends to be the dispute side of it. So that's one. And on the commercial side of either renewables or non-renewables, I would say the market has been, generally speaking, right, we could talk Brazil or globally, incredibly volatile, more than ever, and that creates tension in the supply chains. You might be talking about oil or gas or LNG or electricity, with a number of different players and an increasingly diverse pool of players, and with a number of sanctions going around for different reasons in different parts of the globe. And that creates a lot of volatility, and volatility impacts price, and price impact the economics of projects, which ended up leading to disputes. So I would say probably those three, maybe regulatory issues on the oil and gas side of the industry, or corporate M&A related on the renewable side of the industry, and market volatility in relation to all commodities, essentially. It's been more volatile than ever. And just to mention, but obviously, some the ESG related issues that everyone is facing, particularly energy companies like ourselves.
That's very helpful for us to know what is in your mind. What do you think is going to be, the subject matters that are going to be keeping us all busy in the years to come. I think before I end, I wanted to ask you a question, because when we talk about future of arbitration, that comes to mind right now, and it's artificial intelligence. AI, specifically generative AI, has been used in international arbitration to streamline process for a long time. We use a lot here. We've been using for years, e-discovery, document review, for legal research analysis. Now, more recently, we have outcome prediction and all those things. And I think that we probably can all agree that it improves efficiency and provides valuable insights. However, we can all agree as well that there are risks and challenges, particularly related to accuracy and privacy. But I would argue that a well-trained lawyer nowadays need to have not only the typical analytical skills, advocacy abilities, all of these skills that we always had to have, but now we need to be tech-driven, have that skill set that takes advantage of something like AI, but at the same time know how to manage the risks. So as a client, do you expect AI to bring efficiency and effectiveness to the disputes? How important it is for you that lawyers make use of AI to speed up disputes, to reduce costs, and which measures would expect them to address the concerns I just mentioned? If you have any thoughts on this, you may not have given much thoughts to artificial intelligence, but I wonder if this is something that you guys have been discussing internally, and what your expectations about it are.
Thanks, Erica. I think the answer to your first question, I'd say, is yes. I personally expect that the use of generative artificial intelligence will increase efficiency in the arbitration space, as it has been increasing efficiency almost everywhere when it's been applied. And I do expect the lawyers, outside counsel, in-house counsel, myself included, to be more well-versed on how to use those technologies and how they can be used to the benefit of our case in any particular matter, but also to be acutely aware of what are the risks and pitfalls that we'll see along the way, because it's been obviously expanding very rapidly. And I think institutions are really putting the effort and the time in figuring out how to deal with that. And I think we as lawyers, we as those entrusted to resolve the dispute for the clients, we need to be at the forefront of understanding what are the risks and the opportunities that this impose. Sometimes sometimes I feel a bit overwhelmed with the flood of information about EY. I think all of us sometimes have that feeling that we are missing out something, because there's always something new coming out in the market. But I think it's just natural, right? It's a new technology coming in, and we'll have to deal with it. And how it will be applied to disputes, and how disputes over the use of artificial intelligence as the merits of that any given dispute, how those disputes will be decided. So I think that there's a brave new world there, but I'm optimistic. I think it comes for good. I mean, it's been very helpful in so many areas. Why wouldn't be in the arbitration space?
Yeah, no, absolutely. I usually think of AI as a very smart child who is constantly learning, but the child doesn't always know where it is that it got the information from. It doesn't know what it is it doesn't know, but it can remember and share all information, right, that they hear. So I think to mitigate all of these risks, we need to build a reliable database. We need to feed AI with accurate information. And, I think firms have been developing their own services or having providers like Microsoft ensuring privacy. I think there are a lot of things that can be done, but still a lot of challenges in ensuring that AI has access to the necessary information. And I think when it comes to international arbitration, the challenges are bigger because it involves multiple legal systems, highly specific cases, confidentiality that we were just talking about. So we have definitely a long way to go, but it's helpful to have your insights and expectations in this regard.
Thank you. But I admit I need to. I probably need to up my game too. I mean, we've been following up on that, obviously, as everyone else. I personally, but it is a brave new world. And what concerns me more about the use of EY and arbitration is what are the risks that we're not seeing, because we can all see what the upsides are. So, what are the actual downsides, and how we prepare to deal with those downsides.
Yeah, absolutely. Well, thank you very much, Gabriel. Thank you, Pedro, for your time. Thank you for sharing your experiences with us today.
Thank you. Thank you for taking the time to speak with me. Very kind. Talk soon.
Bye-bye. Thank you.